So, which one's being dismissed?
The 9-6 would have rented 1-6.
1916. Okay. Good morning. Are you Patrick Treyan?
Yeah.
And Mr. Treyan, I'm going to take judicial notice of the court's file in all of his cases. Mr. Treyan was evaluated for competency by Dr. Gapon. And we received that report dated March 2nd of 2026. The finding in that report is that Mr. Treyan is currently competent to stand trial. Any other evidence with regard to competency
No, you're.
from the state?
No.
Then at this time, I am going to find that Mr. Treyan is competent to stand trial. Mr. Parker, will your client waive the formal reading of the indictment in each of the cases?
No, you're.
And are we going on count one only? On the assault on a peace officer?
Yes, sir. We may need to go on both on the stage.
Okay, hold on a second. Sorry. All right, Mr. Treyan, in cause number 25, DCCR 1917, the state's elected to proceed on count one only. It alleges you committed the second-degree felony offense of assault on a peace officer, and that's from November 18th of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with? And then takes a minute for me to get it. And clause number 26, DCCR 0592. You're charged with the state jail felony offense of possession of a controlled substance from March 17th of 2025. And how do you plead to that charge?
Yeah.
Again, are you pleading guilty freely and voluntarily?
No.
And because you did what they charged you with? Also, in that indictment, it alleges that you were previously convicted of the state jail felony offense of theft of copper, bronze, or aluminum, August 11th of 2014. And then after that was final, you were convicted of burglary of a building, a state jail felony, May 15th of 2015. And are those two prior convictions true?
Yes.
In each of your cases, I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, I do.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal?
Right.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1 in each case.
Objection.
It's admitted in each case. Get caught up here. All right, so I'm going to find that you entered your pleas of guilty in each of your cases freely and voluntarily. Find that you entered your pleas of true also in the second case freely and voluntarily. Find again that you're mentally competent, that you understand the nature and the consequences of your pleas. And clause number 25, DCCR 1917, find sufficient evidence to find you guilty, and at this time find you guilty of assault on a peace officer. Sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in clause number 26, DCCR 0592, find sufficient evidence to find you guilty, and at this time finds you guilty of the state jail felony offense of possession of a controlled substance. Find those 2 prior convictions true, sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Those 2 cases will run concurrently, which means together at the same time. I'm handing you in each of those cases the trial court certifications that shows that these were agreements that I followed, and so you've waived your right to appeal. I also handed you a trial court admonishment, or the written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. All right, and I will sign that dismissal now in cause number 25 DCCR 1916. All right, you can go back with the bailiff.
Right.
That's the last one. All right, are you Jameldrin Wilridge? And so before we go forward, Mr. Lewis and Ms. Malfino approached about possible solutions to the issues that we have here with Mr. Wilridge is on probation. In 3 cases, there was a new offense that occurred while he was on probation, but before he went to ISF as a part of that probation. And what I want to know before I consider any type of continuation of probation is couple, I guess, number one, how do you have any idea how he did, Mr. Kitchen? I guess, and before you go forward, would you raise your right hand? You swear from the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth.
I do.
Any issues with regard to behavior at ISF that you were aware of?
None that I'm aware of.
Okay, when did he get back from ISF?
I'm not sure exactly. I did not receive Mr. Wilridge under my supervision until September 26th of last year.
Okay, and
So-
how has he done from then until he was incarcerated on this?
That would and he was very cordial with me. We've had cordial bit surprised by this and the other stuff that's been going on with it.
Okay, any positive drug screens, any issues at all since you had them in September?
Mhm.
Okay,
May I just ask him one question for the clerk?
course, please.
Mr. Kitchens, you brought to my attention, and I think the clerk has also sent it to Mr. Lewis and myself. His behavior in jail is less than to be desired, correct?
Yes, that's correct.
And would you characterize that as his association with those individuals who the court is very well aware are in jail? That is a different side of him than you saw while he was out on probation under the guidance and eye of the court and his family.
That's correct. Yes.
With the understanding, I'm sorry, Judge, if
Go
I
ahead.
may, that obviously Mr. Wilridge is facing quite a bit of time from this court on a revocation. And would it be your intention, along with the court and myself, to make it clear to him that if he is given this opportunity, that if he comes back before this court, that he's not looking at maybe what he would be looking at today, but probably 3 times in advance of that amount of time?
Yes.
And do you think he is capable of and understands the seriousness of what it is he's facing
I believe he does. Yes.
from your interaction with him?
Okay, well, Mr. Wilridge, this is tough for me. Because you've been given a couple of opportunities and this would be another opportunity, and I don't know. I don't want you back in here. I don't want you to violate. I want you to be successful. You've been on a decent path. But what you did and thought you got away with, things catch up with you, right? And so that one's a 2 to 20 case. I could revoke you on your ag robbery and send you to prison for the rest of your life today. The rest of your life. And based on the history and what's been going on, some big fat number is probably what you deserve. And so I don't know how to be any more clear than if I give you this opportunity with what your attorney is working out with the district attorney, that Mr. Kitchen sounds like he's willing to work with you. And if I go along with this and leave you on probation and put you on a new probation, if you're back in front of me, there will be absolutely no argument about continuing probation or some low end of the punishment range. That won't be what's happening. Do you understand? You're gonna be on zero tolerance. That means no mistakes on probation. You've been on it long enough now to know how to be successful or not on probation. And if you just live your life right and do what you're supposed to, that shouldn't be a problem. It's only hard if you're doing the wrong things. Does that make sense?
Yes.
All right, y'all can do the paperwork.
Thank you, Judge.
Thank you.
All kinds of new stuff's happened since he was up here, all the words I have to say. Good morning, are you Lloyd Calhoun? And Mr. Parker, will your client waive the formal reading of the indictment?
Hey, will the judge?
And we're just going in the possession case, is that correct?
That's
Right.
correct, Judge, but on the, with the prior enhancement counts to make this a third degree, and just so to be candid with the court, in 2019, he also received a 5-year sentence. This same 5-year offer was made based on the underlying facts of this offense.
Okay.
What he did was pour some PCP out on the floorboard carpet of the car, which made it difficult to measure the quantification.
Okay. All right, Mr. Calhoun, in cause number 25, DCCR 1266, you're charged with the state jail felony offense of possession of a controlled substance from April 14th of 2025. And how do you plead to that charge?
Yes.
And are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with?
Listen.
That indictment further alleges that you were previously convicted of unauthorized use of a motor vehicle, a third-degree felony, May 17th of 1993. After that was final, you were convicted of possession of a controlled substance, a third-degree felony, June 3rd of 2002. And then after that, you were convicted of unlawful possession of a firearm by felon, July 8th of 2019. And are all three of those prior convictions true?
Mhm.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker? He went over those with you? Do you fully understand those documents?
Some of
What do you not understand?
them, I gotta look at it to see it again, but most of them I do.
Well, let me go over a little bit more with you. Do you understand that if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal? So if I follow this agreement, you can't change your mind later,
Yeah.
right? And it looks like the agreement's for 5 years in prison with a dismissal in cause number 25 DCCR 1267, which is that tampering case.
Yeah.
Is that your understanding? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yeah.
State tenders number 1,
No objection?
it's admitted. Is there any evidence that Mr. Calhoun is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty and true freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time, find you guilty of possession of a controlled substance. Find those prior convictions true. Sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive.
Back time?
Yes.
No.
Just the time that we've had a hold on you here. So I don't know if you are serving time anywhere else or were anywhere else. Okay, so you'll get that credit. I'm going to, is it not printing? Okay. I'm going to hand you in just a minute, a trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. You're also going to be handed a written admonishment regarding your ineligibility to possess a firearm or ammunition. You already know this because I know you have a history with a charge of this, but I'm required to read this to you. Because of the judgment entered against you, you are ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. And then I will sign a dismissal as soon as it comes through in clause number 25, DCCR 1267.
So name it now.
You put in the holes.
Well,
I think I probably printed it twice at least.
and this is, what I printed stuff for Pam a while ago,
Oh.
and what I gave her wasn't all of it. Apparently we ran out of paper, but I didn't know.
I printed some stuff also from that other case.
Okay,
I printed one for me, several things for myself.
well, I think it's something.
Okay, all right. Here you go. You can go back with the bailiff.
No. Yeah.
You want to put your misdemeanors at 2 to 3? You do.
Okay.
Good morning, sir. Are you Eric Treyan?
Yes, you know.
And Mr. Parker, will your client waive the formal reading of the motion?
Here we are.
Mr. Treyan, in cause number 22-40541, I have a motion to revoke your community supervision. It shows that you were placed on probation January 17th of 2023 for evading arrest or detention with the use of a vehicle, a third-degree felony. And that was a 10-year term in prison that was probated for 5 years. Is that correct? The motion alleges that you violated your probation. Count 1 alleges that you committed the offense of reckless driving November 28th of 2025 in Jefferson County, Texas. And is that true or not true?
True.
Count 2 alleges that you provided a urine sample March 10th of 2025 that tested positive for the byproducts of cocaine. And is that true or not true?
True.
And then count 3 alleges that you have failed to provide verification and performing the community service hours as required. Is that true or not true?
True.
Did you enter your pleas of true to counts 1, 2, and 3 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're actually true?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them, that the state's marked as exhibit number 1. Before you sign these, did you go over them with Mr. Parker?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for me to continue you on probation, but order that you enter and successfully complete the safety program. And then you would be back on probation and required to follow all of the rules and conditions. Is that your understanding?
Judge, that was the recommendation when I spoke with this officer, Georgie.
Okay, thank you, Ms. Malfino. And it looks like also you would enter a plea on that reckless driving for the time that you've already
I
served.
think you can get your credits. We're probably gonna dismiss it, Judge. I mean, it's,
He's got so much
Oh,
credit
okay.
that it
How-
makes it technically easier.
yes, we're gonna resolve that today.
Let him go.
Okay, so then what I'm gonna do, Mr. Tran, it sounds like everybody's wants to get you back on track, and that's what safety is for, so that you can have the tools necessary to be able to stay clean and do everything you're supposed to on probation. And so I'm going to follow the recommendation from probation and the district attorney's office. Find that you entered your pleas of true to counts 1, 2, and 3 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke the probation, but I'm not going to. I am going to continue you on probation. I'm going to order that as a condition of that probation, you enter and successfully complete the safety program, and then follow all of the other rules and conditions of probation. If you do all of that, we should never see each other here again,
Yes, ma'am.
and you'll be able to finish that probation or your time while you're out on probation. But you need to keep in mind, if you mess up again, you're going to be back here in court, and we're not going to be talking about the same type of thing. You'll end up going to prison. You've already agreed to a 10-year sentence.
Yes, ma'am.
Okay, good luck to you, sir. You can go back with the bailiff.
No,
Good morning. Are you Edwinia Johnson?
Yes, ma'am.
And Ms. Johnson's here in cause numbers 24 DCCR 2151, 2152, 2153, and then there is also cause number 25 DCCR 1826. And the first 3 cases are all probation cases that Ms. Johnson is currently on, and there's been a motion to revoke filed in each of those. The underlying offenses are forgery, abandoning or endangering a child, in the other two, and then that new offense, is for robbery. Ms. Holmes filed a motion asking, for me to set bonds in those three underlying motion to revoke cases. She's on deferred, but I set it for a hearing based on that underlying offense. I want to know really what's going on before I figure out, an amount or if I'm going to set bond. So Ms. Holmes, I'll let you go first. You're gonna call your client for purposes of.
Yes, Your Honor.
Ms. Johnson, best you can, raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. You may proceed.
Okay, you, Edward A. Johnson?
Yes, ma'am.
Okay, Ms. Johnson, how long have you been, in custody at the Jefferson County Jail?
2 months and 8 days.
Okay, and, you're in there because you understand that there were motions to revoke probation due to, allegations that you violated probation, correct?
Yes, ma'am.
Now, the, alleged offense of robbery, is one of the underlying allegations. You're understanding of that, correct?
Yes, ma'am.
In which the offense date was not very long after you were placed on probation.
Yes, ma'am.
Okay, we've discussed that, while you have, been in custody, we've talked about you trying, wanting to get back on track with probation and, while all of this is pending, correct?
Yes, ma'am.
Now, if the judge was to, set a bond, where would you be residing? You don't have to give the exact address, but would it be in Beaumont?
It was in Port
Or-
Beaumont,
Okay,
either or.
okay, and, you have, family who have obviously reached out to me who would be, supportive of you, to make sure that, you come to any and all court proceedings, and that you do whatever is necessary, and that you understand that if you, are given a bond, that there may be certain restrictive measures, such as GPS monitoring, things of that sort, placed upon you.
Yes, ma'am.
Okay, and, are you asking the court, to set a reasonable, bonds in your cases so that you can hopefully, be released and, try to get back on track with probation? It doesn't seem that you got very far with starting probation because you hadn't been on it very long. Is that
Yes, ma'am.
correct? Okay, and so you're asking for bonds to be set so that you can try to get back on, track with that.
Yes, ma'am.
I'll pass the witness, Your Honor.
No questions.
All right, any other witnesses?
No, Your Honor.
Mr. Smith?
Judge, because they're deferred, I believe that you have to set a bond. We would request those be fairly significant bonds. The underlying offense, even though it's not with strangers, it's people that she was living with. There was an argument, it turned violent. This defendant did not live there, but she was there. She gets in on it, holds her down while they take this other person's phone, ripped it right out of her hands. So this is 1 week after she went on probation in these three cases.
Last week.
Not yet.
And obviously she doesn't understand the significance of what is being held over her head. I don't know that I would offer to keep her on probation based on that without some kind of significant cognitive treatment so that she would understand how to make better decisions. But we would request those bonds, like I said, to be significant.
So probation started in all three of these cases, October 6th of 2025.
Yes,
And
ma'am.
so probation's here. And ma'am, would you raise your right hand, please? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. And so were you able to have any meetings with the defendant, Ms. Johnson?
Yes, ma'am. I met with her in October when she first got placed on probation and then again in November. But when the offense occurred, she then reported to me when I met with her in November. And that kind of was alarming to me. And then also in November, she told me that she was in Houston. No, I'm sorry, I think that was December. She went to Houston without letting me know first, so that was also another concern. And so there may be some compliance issues with that.
Okay. Ms. Holmes?
Well, Your Honor, based being that she's on deferred, we would ask that a reasonable bond be set. I do understand the concerns of the department and the state, being that she wasn't on probation very long at all before the new alleged offense occurred. And with speaking with Ms. Johnson, and she is realizing the severity of the cases that she is on probation for, and she has expressed to me that she wants to get this right and get back on track with babies.
For the record, I'm reviewing at this time the probable cause and the underlying offense. Give me just a second, please. Who's taking care of your kids, Ms. Johnson?
My brothers and my sister and the boys are with their father people. There's
Okay. Obviously, it gives me a whole lot of concern that she was on probation for a week. Obviously, they're allegations, but they are serious and it shows.
Notice what the judge is doing here. She isn't deciding guilt or innocence, she's deciding whether the defendant can safely await trial outside jail. High bonds, GPS monitoring, house arrest, and strict no-contact orders are all designed to balance public safety with the defendant's legal rights. Now it's your turn. Do you think these bond conditions are appropriate, or should the court have been even stricter?